What was the maximum number of lawyers you supervised in your job at the solar company?
None, Senator.
Have you practiced law anywhere else other than that as an associate in the firm that terminated you and in the solar company where you supervised no lawyers?
Senator, I have not.
Have you ever tried a case to verdict?
No, Senator.
Have you ever argued a motion?
I have not, Senator.
Have you ever authored and signed a legal pleading?
I have not, Senator.
During that period, did you take the bar and fail to pass?
I did one time, Senator, yes. But
What happens when a nominee for one of the government's top legal jobs is asked about their courtroom experience? Senator Sheldon Whitehouse's questions quickly exposed a resume that came under intense scrutiny.
What was the maximum number of lawyers you supervised in your job at the solar company?
None, Senator. Not at the solar company.
In your work as an associate in the Buffalo law firm, did you hold yourself out as an environmental attorney?
As an environmental lawyer, I did.
You spent 1 year and 6 months practicing law for that firm in Buffalo, correct?
I was located in that firm in Buffalo, yes, Senator.
Yeah. And you were terminated by that firm after 1 year and 6 months?
That is correct, Senator. If I may just add some color to that.
Well, I have pretty short time, so we can follow up with QFRs, because I promise you there'll be QFRs
Understood.
on this. Have you practiced law anywhere else other than that as an associate in the firm that terminated you and in the solar company where you supervised no lawyers?
Senator, I have not.
Apart from your associate experience in Buffalo and the solar company, have you practiced law in any other place?
I have not, Senator, but I was at the agency before in the first Trump administration.
Not in a legal position?
That's correct, Senator.
Have you ever taken a deposition?
I have not, Senator. This is probably the closest I've ever come to that.
Have you ever tried a case to verdict?
No, Senator. In the firm and at the solar company, we relied on, in the solar company, we relied on outside counsel.
So you were providing inside advice at the solar council rather than active litigation work?
It was an in-house counsel role, yes. But
have you ever argued a motion?
I have not, Senator.
Court?
But as you
know what a motion in limine is?
I do vaguely, yes.
Well, you should have been better prepped, because John Kennedy asks this question.
Yes.
Have you ever authored and signed a legal pleading?
I have not, Senator. But
there was a gap of several years between your graduation from law school and when you entered the bar in Washington, D.C. During that period, did you take the bar and fail to pass?
I did one time, Senator, yes, but
in
there
what
was
jurisdiction?
What, sorry?
In what jurisdiction did you take the bar and
Washington,
fail to
D.C.,
pass?
Senator, but there was a gap before I actually took the bar. I wasn't sure if I actually wanted to go and practice law, to be frank with you.
Under what circumstances would you counsel the EPA administrator to violate a court order?
After this hearing, the Senate Environment and Public Works Committee advanced Donahue's nomination on a party-line vote in April 2025, despite continued criticism from Democrats over his legal qualifications.
Senator, thank you for that. I would never counsel the EPA administrator to violate a court order.
Under oath, can you assure us now that EPA is presently in compliance with the federal court decisions by Judge Ali Khan and Judge McConnell right now?
Senator, I believe that the agency is.
When a public official makes public accusations of criminal activity with no credible evidence to support the accusations, what legal liabilities and concerns does that raise?
Senator, as you mentioned in opening, potentially defamation, that sort of thing. But I'm not a criminal investigator. I'm not at the Department of Justice. I don't handle the various aspects of that criminal probe, so I'm not privy to that information.
There is an internal memorandum out of the agency's counsel office that relates that a significant number of grants.
In the months that followed, disputes over EPA grant cancellations continued in federal court, with multiple legal challenges focusing on whether the agency had followed the terms of its grant agreements and federal administrative law.
were terminated based on a significant error, agency's words, in the terms and conditions for those grants. As the Washington Post reported today, an agency lawyer warned officials that they had cited contractual language that did not apply to many of the grants the EPA had ended in recent weeks. Grants had been terminated on grounds that they no longer fit the agency's priorities, referring to a clause in their grants' general terms and conditions that applied only to grants issued between August 13, 2020 and September 30, 2024, and almost half of the terminated grants were finalized outside of that relevant period. Have the grants impacted by this significant legal error been restored to the recipients?
Senator, I've seen the reporting on that. We received your letter, in fact, 2 letters yesterday on this. I was not on that email. I think it was an email, not a memorandum, but I think we're working to track an answer down for you on that.
Since this March 26, 2025 Senate Environment and Public Works Committee hearing, Sean Donahue's nomination continued through the Senate confirmation process. On April 9, 2025, the committee voted to report his nomination favorably to the full Senate. The Senate later invoked cloture and on May 15, 2025, confirmed Donahue as an Assistant Administrator of the Environmental Protection Agency by a 51-46 vote, allowing him to assume the position. His confirmation came despite Democratic senators continuing to question his litigation experience, legal background, and qualifications during the confirmation process. Since taking office, the EPA has continued implementing the Trump administration's regulatory agenda under Administrator Lee Zeldin, including reviews of environmental regulations, grant programs, and enforcement policies. Many of those actions have generated continued litigation in federal courts, with judges considering challenges involving grant terminations, environmental rules, and agency authority. Congressional oversight has likewise continued through multiple EPA budget and oversight hearings, where lawmakers from both parties have questioned agency officials about compliance with court orders, the handling of environmental grants, and the legal basis for major policy decisions. These issues remain active subjects of litigation and congressional review. The hearing itself focused primarily on whether Sean Donahue possessed the courtroom experience traditionally associated with a senior legal leadership position at the Environmental Protection Agency. Senator Sheldon Whitehouse methodically questioned Donahue about his professional background, highlighting that much of his legal career had been spent in private practice and in-house counsel roles rather than active litigation. Whitehouse noted that Donahue had never taken a deposition, argued a motion, tried a case to verdict, or personally signed legal pleadings, raising questions about whether his practical litigation experience matched the responsibilities of a senior EPA legal official. Donahue acknowledged many of those limitations while explaining that his work at a solar company focused on providing internal legal advice rather than conducting litigation, with outside counsel handling courtroom matters. He also candidly acknowledged that he had failed the Washington, D.C. bar examination on his first attempt before later becoming licensed. Rather than disputing the factual record presented by Whitehouse, Donahue argued that his broader legal and policy experience prepared him for the position despite a relatively limited trial background. The hearing then shifted from qualifications to the EPA's legal obligations. Whitehouse asked whether Donahue would ever advise the EPA administrator to violate a federal court order and sought assurances that the agency was complying with existing judicial rulings. Donahue responded that he would never counsel the agency to disregard a court order and stated that he believed the EPA was complying with applicable judicial decisions. Those questions reflected broader congressional concerns about ensuring executive agencies faithfully implement court rulings, even when litigation over agency policies remains ongoing. Another significant portion of the exchange centered on recently terminated EPA grants. Whitehouse referenced internal agency communications and media reports suggesting that numerous grant cancellations may have relied on contractual language that did not apply to many of the affected awards. He questioned whether grants impacted by what he described as a significant legal error had been restored. Donahue replied that he was aware of the reporting but had not been directly involved in the internal communications and committed to providing additional information in response to senators' written questions. The hearing illustrated one of the Senate's recurring responsibilities during confirmation proceedings. Beyond reviewing a nominee's resume, senators often examine whether candidates possess the practical experience, legal judgment, and professional independence required for positions involving significant governmental authority. Whitehouse's questioning suggested that technical legal experience and courtroom familiarity remain important considerations for senior legal appointments, particularly within agencies that routinely defend major regulatory actions in federal court. More broadly, the exchange reflected the continuing tension between legal qualifications and policy leadership. While some senior executive positions emphasize litigation experience, others require management, regulatory expertise, and the ability to oversee large legal teams handling complex administrative matters. The hearing demonstrated how senators weigh those competing considerations when evaluating nominees responsible for advising federal agencies on matters involving environmental law, regulatory enforcement, and ongoing litigation. Looking back, the hearing became part of the broader debate over the qualifications and accountability expected of senior executive branch officials. Questions about professional experience, compliance with judicial orders, and adherence to established legal standards remain central to the Senate's constitutional role of providing advice and consent on presidential nominations, particularly for officials entrusted with overseeing major federal regulatory programs.